Welcome to part 2 of our series of protest seminars. We are going to, this is going to last an hour and a quarter. Everyone's going to speak for about 15 minutes each, and so that will leave you lots of time for questions. So my name is Maya Sikand, and I am the head of our Civil Liberties and Human Rights team. So our first speaker is Mike Gould. He's a member of our criminal team. He's waving at you now, and he's going to talk to you about Kettling. He's a criminal defense barrister. He has particular expertise in public order and police powers. He's defended in loads of cases from high-profile protests over the last decade, including Extinction Rebellion, cops off campus, and in anti-fracking campaigns. He's also been a legal observer at a number of demonstrations, and I think so far has managed to avoid being arrested. So, no, you haven't. Okay, so he'll tell you about that maybe. Okay, Mike, over to you.
Thanks, Maya. Right, I am going to, I hope, share my screen without giving away anything too much, because there are some slides that I'm going to refer to. Yeah, good stuff. So I'm going to talk to you guys about Kettling, the law behind it, when it is and isn't lawful, and also a specific aspect that arose in a case and some demonstrations about 8 years ago, which came to the fore in the case of Mengesha versus the Met Police Commissioner, where the police appeared to be using Kettling tactics to obtain demonstrators' personal details, evidence gathering. May be relevant in the current circumstances because there's been reports from recent anti-racist demonstrations that despite being told very clearly by the High Court 7 years ago to stop doing that, the police have been doing that again. So Kettling and Kettling as evidence gathering is mainly going to be my focus. So apologies if some of this is familiar to a lot of you, but not knowing how much experience or knowledge all the attendees have on public order law, I'm going to go through some of the basics with Kettling to begin with. So what is Kettling? You have a helpful picture of it here. It's a police tactic, often referred to by as containment, so that's what the police generally refer to it as. Effectively, it's a tactic whereby the police contain a group of individuals, normally it happens at protests, where they are anticipating or there has been alleged disorder, and so they effectively prevent the group from moving or leaving by either completing a complete cordon around the group or by containing them in an area by blocking off the exits from the area. The basis by which the police justify Kettling, the lawful justification for it, comes from the common law, not from statute.
Mike, sorry, could you speak up? There's a problem hearing you. Sorry to interrupt you.
Please do say if that happens again. The mic on my laptop sometimes goes sketchy, so sorry. This is another picture of Kettling. This is probably what it looks like more often on the inside of a kettle than the last photo. It's derives from common law powers of police officers to either prevent or suppress an ongoing breach of the peace. Now, a breach of the peace was defined or given a definition in the case of Howell, and I've given it there, which is a breach of the peace is harm actually done or likely to be done to a person or their property in their presence, or where a person fears being so harmed by public disorder. That's not a direct quote, that's a paraphrase, but that gives the essence of it. And that definition itself has actually been criticized a little bit, even in the following case I'm going to refer to as report, because it sort of conflates a breach of the peace with an anticipated breach of the peace. Arguably, the breach of the peace is the disorder or the violence to person and property, and the fear would be more about an anticipated breach of the peace. But this power was revisited again by the House of Lords in the case of Laporte, and that was a case where a busload of demonstrators were intercepted before arriving at a demonstration by police who purportedly feared there would be disorder after these demonstrators arrived at the demonstration. So they basically locked them in the bus and made it turn around and go back without escorting them the whole way, without letting them leave the bus. And they relied, the police, when they had a JR of their actions on breach of the peace powers. And in the report, it was stated that every constable has the power and indeed is subject to a duty to seek to prevent by arrest or action short of arrest any breach of the peace occurring, or that being renewed, or a breach of the peace which is about to occur. Now, in that third category, when you're talking about a breach of the peace that is likely to occur, what Laporte held is that in order for for police to be able to take action, it must be reasonably believed to be an imminent breach of the peace. And there's been some cases that have argued about what imminent necessarily means. It's not a definite time limit, but it is what's imminent. It's in the very near future. And it was on that basis that Laporte, the police, lost, because there was no way they could say that any breach of the peace was imminent. Now, in Laporte, they did go on to say, look, in certain circumstances, because what happened in Laporte when they closed off the bus is that it was innocent people caught up in it. And the House of Lords said, if there's no other way of preventing the breach of the peace, it may be lawful for police to take actions even against innocent parties, if that's the only way of preventing a breach of the peace. And that became relevant then when the case of Austin came before the House of Lords a couple of years later, which was actually related to demonstrations that had taken place on May Day in 2001, where demonstrators had been kettled. The claimant challenged it, and it went all the way to the House of Lords. And of course, because kettling is an indiscriminate tactic, you necessarily contain a load of people, including people who have been in no way involved in any disorder. They had to justify it on the basis that there was no other way of preventing the breach of the peace, in line with Laporte. Now, the Court of Appeal initially said that what the police had done was lawful, and they set out conditions there for when a kettle would be a lawful police tactic. So breach of the peace must be reasonably thought to be imminent. All other steps to stop or prevent the breach of the peace that don't impact on the rights of innocents have already been taken. There must have been proper preparation by the police in advance of any demonstration, so that effectively it's not the police's fault that they're now having to kettle because they hadn't prepared properly. Actions both reasonably necessary and proportionate. And it was noted that this should only apply really in exceptional circumstances. When we got up to the House of Lords, they agreed with the Court of Appeal's ruling, and they also gave more information specifically on the issue of Article 5, because the challenge was on the basis that a kettle deprives people inside of their liberty and therefore breaches Article 5 of the European Convention on Human Rights. And the House of Lords, in quite a controversial ruling, said no, Article 5 doesn't apply to police crowd control tactics, because it's not a deprivation of liberty, but rather an interference with liberty of movement. So apparently being contained in a Oxford circus for 7 hours wasn't a deprivation of liberty, but merely a restriction on the protesters' movement. And it's controversial because they effectively read in a purposive, if that's the right word, purposeful interpretation of Article 5, that the reasons why police are detaining people is relevant as to whether Article 5 is engaged. Now, that's controversial because Article 5 is an absolute right. It's not a qualified right like freedom of expression under Article 10 or freedom of assembly under Article 11, where the purpose of the interference with the rights is a relevant factor in whether this is a justified interference with the right. And the House of Lords basically decided that Article 5 was as well. And they said as long as, they gave 3 further conditions, the tactics were resorted to in good faith by the police, but they were proportionate to the situation, which has made the measures necessary, and enforced for no longer than reasonably necessary, then Article 5 won't be engaged. Now that's weird, because what they're doing there is they're saying apply human rights, classic human rights balancing exercises that you have with qualified rights, proportionality, necessity. But they're basically saying you have to apply human rights balancing exercise before you even decided that Article 5 is engaged to find whether Article 5 is engaged. So arguably doesn't make a lot of sense, but ultimately the European Court of Human Rights agreed with them. So Kettling was lawful. And that's the situation as it currently is, despite the fact that the police said that it should be, or the Court of Appeal, that this really circumstances that give rise to lawful kettling should only arise in exceptional circumstances. Unsurprisingly, once it was given the stamp of approval, certainly by the House of Lords, police use of kettling as a tactic massively increased. And there's been very, very few successful challenges of the legality of kettling tactics. The only one, in fact, I'm aware will be corrected was the case of Moose and others, which was then actually overturned by the Court of Appeal in any event. But then we have the case of Mengesha that I referred to at the outset. So this is where the police appear to be attempting to extend their use of kettling, not just to crowd control tactics, but to evidence gathering. And what happened in that case is there was demonstrators attempted to occupy the headquarters of a mining corporation on Panton Street in central London. Police responded by containing them. And when they were finally letting the demonstrators out, they were requiring them firstly to submit to a search. And there was a Section 60 Criminal Justice Public Order Act order in place, which did allow police to do stop and searches without reasonable suspicion. But also they were requiring people to give their name, an address, and submit to be filmed, presumably for some police database, before they were allowed to leave. And if they refused, they were pushed back into the containment. Legal observers were there. I was one of them. We got caught up in it as well. And so a challenge was brought, a judicial review of the police actions, not challenging the lawfulness of the kettle itself, because Austin had kind of stuffed us on that, but this tactic of requiring personal details, as the court said, as the price of being able to leave. Now, the police lost. Initially, they tried to argue that it was all part and parcel of the containment. Then they tried to argue, okay, actually, we didn't have a power to do that, but everyone gave their details voluntarily. It wasn't forced on them. The High Court said that was absurd. And effectively, the reasoning the High Court gave is like, well, look, the sole permitted purpose of kettling is to prevent or suppress a breach of the peace. It must be maintained for no longer than necessary. As soon as the police are letting people out, by necessity, by definition, it's no longer necessary to contain them to prevent a breach of the peace. So extending the duration as long as necessary to take everyone's personal details is therefore unlawful. And the film that was taken of the claimant, because it was taken unlawfully, had to be destroyed. Now, as a slight side note to this, Section 50 of the Police Reform Act, this is interesting because I think it's come up again in recent demonstrations. Now, this is a power that it wasn't actually specifically relied on by the police in the case of Mengesha. They didn't argue this at court, but the police on the ground were using it, citing it as at demonstrators to say, this is why you have to give us your details. Section 50 of the Police Reform Act allows the police to require someone to give their name and address to the police officer if the officer has reason to believe the person has engaged in antisocial behaviour, which effectively means behaviour which has caused or likely to cause harassment, alarm, or distress. And it was noted by the High Court in Mengesha that police had raised this on the ground, even though it wasn't argued at court. Now, it's interesting they didn't argue it in the case of Mengesha. I always think they didn't argue it because they knew they would lose. And rather than having a ruling saying you cannot rely on Section 50 in this case, they decided to sort of hold back and maybe see if they could try and use it later on in other circumstances. It was a tactical decision, I imagine, not to argue it in court. Now, in my view, very unlikely that Section 50 does apply in public order situations where, certainly in Kettles. Now, firstly, because Section 50 requires reasons to believe the individual person you're asking engaged in antisocial behaviour. And because of the indiscriminate nature of kettling, it's very necessarily they're not going to know who exactly did what. If they did, they would have already arrested that person. So you're effectively using Section 50 against people who all you know is that they were potentially near some disorder, not that they were involved themselves. And secondly, it's questionable about whether public disorder amounts to antisocial behaviour. I mean, I imagine it possibly does in certain circumstances, but the language doesn't quite fit. Although the language of antisocial behaviour, which is causing harassment, alarm, or distress, does feature in the Public Order Act, notably under the offences under Section 4A and 5. The sections which regulate public order situations, and arguably that's what kettling is a way to regulate a demonstration, such as sections 12 to 14 of the Public Order Act, which allow the police to put conditions on demonstrations and assemblies, use much more severe language like serious public disorder, serious damage to property, serious disruption to the life of the community. So, is potential disorder in a demonstration that's perhaps about to kick off enough to argue harassment, alarm, and distress? It's questionable. What's interesting, however, is that bringing us on to the current situation, this is where I'll finish. The reports are that police did exactly the same thing again 2 weekends ago, where there was quite heavy-handed police response to demonstrations in central London led by groups like Black Lives Matter. Demonstrators were contained, legal observers within the demonstrations were again contained, and they were told that they had to give their personal details when leaving. And if they didn't, they were told they had to get back into the kettle. And when they were leaving, they also had to be filmed. And in fact, in an escalation from what happened in Mangeisha, reports that they were being told they had to submit to filming by specific facial recognition cameras. There's some anecdotal reports I've heard that apparently the police were saying, when questioned on this, because some of the legal observers specifically raised the case of Mangeisha, where they've been told this was unlawful, the police were responding saying, well, Mangeisha rights don't apply here. I don't quite know what that means, because it seems to be a completely almost identical situation. And also the fact is Mangeisha didn't actually create any rights. It didn't bestow new rights on demonstrators. It simply said that the police didn't have the power to do what they were purporting to do. It may well be that there are legal challenges to the police actions at those demonstrations, and Mangeisha is relied upon. We'll have to see what they say. And again, there's reports that they were citing Section 50 of the Police Reform Act as justification for requiring people's personal details. So is this some confidence that the police think they'll win this time round because they think they've got more of the judiciary or the politicians on their side? Was it just some idiot chief inspector who didn't know about Mangeisha, which would seem to be undercut by the fact that some officers were saying Mangeisha rights don't apply? We'll have to see. But the strict position is, if you find yourself in that situation, you are not required to hand over your details. That's the law. Of course, the practice is you might find if you don't that you're pushed back into a kettle or even arrested for breaching Section 50, and you'll have to fight it in the courts. So that is a quick overview, I hope, of Kettling and other issues related to it. And with that, I will hand over, I believe, to Danielle.
Thank you, Mike. Bang on time. Thank you. So our next speaker is one of our up-and-coming stars, Danielle Manson. She joined us during lockdown. So that was quite a feat. She is a member of the criminal team and does some police action work. She has extensive experience already of representing those charged with criminal offences arising out of protests, including Extinction Rebellion and Stop the Arms Fair. She's also a committee member of the newly formed grassroots organisation Black Protest Legal Support, which was formed in the wake of the Black Lives Matter movement following George Floyd's death. She's also been a legal observer and has been responsible for training and coordinating, over 100 barristers and solicitors as legal observers. So over to you, Daniel. Oh, Daniel's going to talk to you about automated facial recognition and explore a little bit about the Bridges case, the Southwest Police case, which you will all know something about, but she's going to tell you a lot more about. Thanks, Danielle.
Thanks, Maya. I'm going to try and share my screen now, so bear with me while I sort that out. And is that working for everyone? Yep, I've got thumbs up. Okay, great. So as Maya says, I'm going to just be going through what the powers are in relation to live or automated facial recognition technology. It's got a slightly different name. Sometimes it's called LFR, sometimes it's called AFR. And Louise, who's speaking after me, is also going to be touching on the use of LFR, but she'll be looking more at some of the issues that arise from it. So what is LFR? In short, it comprises of a watch list of images of people of interest, which is compiled by the police. They already have the explicit power to require and retain and use images of individuals pursuant to PACE. But that watch list is compiled, and then the LFR and AFR technology is used alongside a camera, which will scan a crowd of people in real time, and then it will use biometric facial mapping to indicate if someone matches with one of the images that's on the watch list. And so I've put a quote here from the Bridges case, just outlining the slight nuanced difference with this technology. Thus, whilst the use of CCTV cameras is a premise for use of AFR, AFR technology goes further. A CCTV camera simply captures digital video recordings. AFR technology uses that digital information to isolate pictures of individual faces, extract information about facial features from those pictures, compare that information with the watch list information, and indicate matches between faces captured through the CCTV recording and those held on the watch list. And I think Louise is also going to talk to you a little bit more about things from a tech angle as well. I'm not so experienced with that, but in short, that's what it is. If from using that technology there's no match, then the facial biometrics or the image of that person is deleted. But if there is a match, then that match is then reviewed by a police officer. Again, another quote from Bridges that just says the human eye is used to ensure that an intervention is justified. And then off the back of that, consequential action will be taken. And I'll go on to talk a little bit about what action can be taken. So the categories of people that can be on the watch list: people wanted on warrants, people who are unlawfully at large, having escaped from lawful custody, people suspected of having committed crimes, people who may be in need of protection, so missing persons, individuals whose presence at a particular event causes particular concern. Obviously a question mark over how that is determined, presumably by reference to information held on the police databases, so police intelligence. Persons of possible interest for intelligence purposes, and vulnerable people. Now, what I would hope that people could take away from this is that the use of LFR and AFR technology is based solely on existing police powers under statute and common law. So there's no new specific dedicated statutory provisions that governs the use of facial recognition technology. And the police's consequential action, what they do with that match from the LFR technology, will depend on what category that person has been put on the watch list. And there's a little bit of information later on about what South Wales Police were doing in terms of their watch list and how they were categorising people, that I'll go on to talk to you about shortly. Also important to note that LFR technology, it's not a form of covert surveillance, and it was held in Bridges that if LFR were to be used covertly, then it would of course be subject to RIPA. And also just another point to note, if anyone is looking at these cases or incidents of facial recognition being used, that the police don't have a general right to detain or otherwise deal with people just because it would help them, you know, with efficiency, just because it would help them more readily exercise their functions in terms of investigating crime. And that principle comes from the case of Iqbal. Basically, here the court held that the duty of police officers to bring offenders to justice doesn't provide them with broad powers, which they are entitled to exercise when and how they think is reasonable to do. Even if, assuming they have those powers, it would be reasonable. And it runs through, obviously, the key police powers that many of us will be aware of: Police and Criminal Evidence Act, the Criminal Justice Act, etc. And at the end, they go on to conclude that the powers do not extend to a right to detain a citizen because it would help the police more readily exercise their responsibilities. So that's something that obviously has to be borne in mind when looking at the use of facial recognition technology, because it's clearly going to be a more efficient way of identifying individuals in a crowd, but it doesn't then follow automatically that the police can simply go and detain them just because it would assist with the efficiency of their investigation. So as Maya mentioned, there's the leading case of Bridges against South Wales Police. And it's an interesting read. If anyone's got time to go through it, it quite clearly sets out the issues that are engaged. That in that case, the claimant, Mr. Bridges, wasn't on a watch list, so he wasn't approached by the police. He wasn't detained for any reason. He was just aware that the technology was used and that his personal information was being run through the LFR and being captured in that way. Interestingly, today, as I understand it, unless COVID has put the kibosh on that, Bridges is being appealed as we speak. So it will be very interesting to see what comes out of that case. But in short, it concluded that the use of LFR technology was lawful, that the lawfulness was being challenged for various reasons, but the court held that it was lawful. And in light of that judgment, there was an opinion that was published by the Information Commissioner in October 2019. And whilst obviously the Information Commissioner accepted the High Court's determination in Bridges, the Commissioner did express concern that the decision in Bridges should not be used as blanket authorisation for the use of LFR technology in all circumstances. In the case of Bridges, they also talked about the different ways that the LFR technology was being used. So the technology that was being challenged was AFR Locate, which is, as I've described, used to scan large crowds. But there was also another technology used by South Wales Police called AFR Identify. And this was basically where unknown suspects and persons of interest their photographs was run through the same technology and compared with the custody images that South Wales Police had to see if the facial mapping could identify who an individual was. That wasn't an issue in Bridges, but it's just a little bit of background for the ways in which the technology is being used and developed. In relation to South Wales Police at the time, they were the national lead for the use of the technology, and they've been conducting trials since mid-2017. The first deployment, or I think the first time an individual was arrested using the technology, was at the UEFA Championship League final. The Secretary of State had been providing funding to South Wales Police to develop the use of it. And there was also an oversight and advisory board that has been created. Its terms of reference are available on the internet, and they consider the use of facial images and the technology being used by law enforcement authorities. But obviously, what's now happening is more police forces are using the technology, and what Mike was referring to earlier, the use of the technology at the Black Lives Matter protests. I was actually out there on the ground at the time and heard about subsequent reports of it being used. So we know that the Met is using it as well. So in relation to what the court held in Bridges, they have stated, and just, I hope I've already covered this, but it's quite a nice succinct way to explain it. If during a deployment of AFR Locate, the software identifies a possible match between a face captured on the CCTV and an image on the watch list. The two images are reviewed by an AFR operator, the system operator, who's a police officer, to establish whether he believes that a match has in fact been made. In our view, the fact that a human eye is used as an intervention is justified is an important safeguard. If, upon reviewing the images of the person on the watch list, the person whose image has been captured by CCTV, the system operator does not consider they are the subject of interest, then no further action is taken. If, however, he believes there is a match, he may inform other officers stationed nearby who will intervene. So, as I've said, if no match, the image is disposed of. They then go on to talk about the use that South Wales Police made of a traffic light system. And this is what they were using in the Bridges case. So Mr. Bridges wasn't on a watch list, so we don't know where he would fall if he were to be on it. But red here indicates the need for an immediate response because of a counter-terrorist threat. Amber indicates the need for an arrest intervention, and green indicates the need for an identification for intelligence development purposes only. So that's the system that South Wales Police was using, traffic light system. Now, as I mentioned earlier, there are no new police powers. So there's no new Facial Recognition Act that can be used. What the court held in Bridges was that the police powers are contained within common law, and paragraph 69 to 72, they run through what those powers are. And there are quite a few cases that are referred to. Here they refer to Lord Parker in Rice and Connolly, and they say it's part of the obligations and duties of a police constable to take all steps which appear to him necessary for keeping the peace, for preventing crime, or for protecting property from criminal damage. There is no exhaustive definition of the powers and obligations of the police, but they are at least those, and they would further include the duty to detect crime and bring an offender to justice. And then go on in paragraph 70, and they talk about the case of Wood. And this is in relation to the use, retention and disclosure of imagery. And so the taking of photographs in the present case was lawful at common law, and there is nothing to prevent their retention. And so this is where the police derive their power to use the software that scans through and obviously compares people on a watch list. Paragraph 71, they cite the case of Cat from 2015, the Supreme Court case, where they considered the lawfulness of collecting and retaining personal information. And here, Lord Sumpton held that at common law, the police have the power to obtain and store information for policing purposes, i.e., broadly speaking, for the maintenance of public order and the prevention and detection of crime. These powers do not authorise intrusive methods of obtaining information, such as entry onto private property or acts other than arrest under common law powers, which would constitute an assault, but they were amply sufficient to authorise the obtaining and storage of the kind of public information in question on these appeals. And so that has been used as justification for the use of this technology, widely being used at large-scale public events. And finally, in the case of Helliwell here, it's cited. The key is that they must have these and only these purposes in mind and must make no more than reasonable use of the picture in seeking to accomplish them. And so Bridges well and truly made clear that in the court's view, at the time that case was being heard, the police have ample and sufficient power to use this technology in the way that it was being used in Wales by South Wales Police. Now, obviously, we haven't yet had a legal challenge in relation to the use of facial recognition, compliance with facial recognition technology as a condition of leaving a kettle. And Mike's touched on that briefly, and that may be something that is subject to further challenge in the future. But in terms of just being used generally to capture people going about their daily business, the court said LFR is fine to be used. And again, this is just another paragraph from Bridges where the common law power is mentioned. So to summarise, really, the police are permitted to photograph people as they go about their daily business. We know that from the case of Woods and Cat, and Bridges made that very clear. And so as it stands, that would extend to the deployment of LFR or AFR technology as well. However, what we should be very clear about is there's no specific police power to take an image of someone's face, and therefore there's no legal duty for someone to make their face available for images to be taken by the police unless and until the threshold for arrest is met. And obviously what's very interesting is that during the Black Lives Matter protests that have been taking place recently, it's also taken place in the wake of the COVID pandemic. So the majority of people already had their face covered. And so the question would therefore arise as to whether or not the police would or could require someone to remove the face covering that they're legitimately wearing due to government guidance in order for them to be captured on the footage. And then just as a final point, obviously, if someone is then identified by virtue of LFR or AFR, whether or not the police can exercise their ordinary powers of arrest will depend on all the circumstances. So LFR and AFR technology is a means of identifying someone, but then of course the next step is, well, what do the police do with that information when they use the technology to know that someone's in a particular place? Well, of course, that will depend on the factual scenario and what category of the watch list an individual falls in. So in the South Wales Police case, whether they're red, amber or green. Yes, Maya, this is my last slide, thank you. And so I think Louise is going to touch on this in her talk, but I just wanted to leave one final quote from another case that is referred to in Bridges. So the protection afforded by Article 8 of the Convention would be unacceptably weakened if the use of modern scientific techniques in the criminal justice system were allowed at any cost and without carefully balancing the potential benefits of the extensive use of such techniques against important private life interests. So I'll finish there and hand over to Louise.
Thank you so much, Danielle. I know you've all got a load of burning questions for Danielle, and she is going to answer at least some of them, but I'm going to let her have a look at the questions, and then I'm going to field them to all the speakers as appropriate afterwards. So I'm going to move on to Louise, who is a member of our Civil Liberties and Human Rights team, and she specialises in migration, women's rights and discrimination. She tells me that whilst waiting to catch a satellite space launch on sabbatical in South America, she learnt the basics of programming. That sort of leads on to her current interests, which relate to whether or not algorithms can ever be fair, and the consequences of AI for public and private decision making. She recently spoke on the human rights implications of global deployment of public health technology at the African Legal Network International Webinar, Data Surveillance, Viral Pandemics, and on the subject of accountability in AI at CogX. So she's just going to speak to you a little bit more about facial recognition technology, but less about the law and more about the implications, which will probably end up making you feel quite uncomfortable. So be warned. Lou, over to you.
Thanks. I'm just going to try sharing my screen. Which is now. So in preparation for this, I was at a meeting this morning discussing the need for a new vocabulary to define the relationship between the human and the artificial intelligence that we're using. And I talked about facial recognition and was told in categorical terms, the software is not performing facial recognition, it's doing data correlation. It can only annotate one set of data to another database of known data. It's doing a probability calculation and not recognizing a face. And that is quite fundamental in terms of understanding what it is that facial recognition technology does. And there's a lot of interesting academic work currently being done on whether or not algorithms based on probabilistic reasoning can ever be fair or just because of the space for error. I'm starting with these pictures because they are publicly available pictures of some members of the team and myself at protests. And the one on the right was a protest that was organised on, or our participation in it was organised on Facebook. We met outside a cafe, and at that point, the police sent one policeman to come and watch us for a bit. So I'm presuming that one was through a risk assessment conducted after intelligence gathered from Facebook. And I'm going to come back to that at the end. So looking firstly at live facial recognition and how does it work? You start with a neural network which learns what a face is. You train the resulting algorithm on a data set to recognize different faces by mapping them. That's best done using a second neural net so you don't contaminate the results. You create a watch list of wanted people, which I'll return to later. Police go out, take pictures of people in real time. The software detects and isolates the faces in the picture. It extracts unique facial features to create biometric templates unique to the image. And then that template is compared against the watch list for a match. So the first thing to consider is the training data. And it's notable that in Bridges, the expert who looked at the technology didn't have the training data. And I suspect this is likely to happen time and time again because of commercial sensibility, that companies are unwilling to release their training data. It's important to know which data sets are being used because, for example, one of the biggest sets of data is comprised of a data set of celebrity faces, of whom 77.5% were male and 83.5% were white. So that tells you what this software is being trained on. And so the reliability and accuracy of it is likely to differ if you don't fall within that training data. So the first question really is the data set itself sufficiently diverse? And the second question is, how is that data set labeled? And there are traditional kind of labels like gender and race, but more recent research, which I'll come to in a minute, suggests that skin type is equally important and hasn't been factored into any of this research. The final question really is, how has the accuracy of the data set been tested? If the accuracy is tested on the same set of data as the model was trained on, it only tells you that it can recognize the data that it was trained on, and not that it's necessarily going to work in a real life situation. So the data that I'm referring, the research I'm referring to in respect of skin tone rather than race is the gender shades research by Joy Bulamwini at MIT. She and her team firstly noted that much of the original testing of accuracy had been done by testing the data in the wrong way, and then set out to use an intersectional analysis by evaluating the accuracy of various systems on 4 subgroups: darker females, darker males, lighter females, and lighter males. And the results of this research was that there's a significantly higher rate of false positives for female versus male, and that within the group of darker females, there's an error rate of up to 35%. Now, this research was done in 2018, but it didn't have much consequence until the Black Lives Matter protests over the last few weeks, when it resulted in firstly IBM, then Amazon, and then Microsoft saying that it would not be appropriate for their facial recognition technology to be used by law enforcement agencies in the US unless there was specific law to govern the appropriate use of that technology. So where's the UK now, if that's the US? Well, as we've heard, the South Wales Police are in court defending the lower court decision in Bridges that the interference with the right to privacy is necessary and proportionate. There's no need for any additional legal framework to govern the use of facial recognition technology, and there are no Data Protection Act implications. The Metropolitan Police Service are rolling out the use of live facial recognition across London, and it's interesting to hear the stories of how that's being used, particularly given that their own website says, I quote, "Anyone can decide not to walk past the live facial recognition. It's not an offence or considered unlawful." And we have a government that's committed to more and more investment in artificial intelligence and technology. Matt Hancock, Dominic Cummings, and the track and trace fiasco might be one thing to look at. They've recently produced a document about good practice in AI procurement, which is a great document in principle, but I currently query the application of it in practice. So, bearing in mind that your training data is probably already flawed on race and gender grounds, the next thing that you have to look at is the Watchlist data. And in Bridges, they did find that the inclusion of a person on any watchlist and processing of that data without sufficient reason would most likely amount to an unlawful interference with the person's Article 8 rights. However, it's unclear how you'd get access to that and what the criteria are for inclusion. And what does seem to be clear is that the criteria for inclusion on a watch list change depending on the deployment and the use of it. So there's a detailed study done by the University of Essex, which was done in July last year, on the Metropolitan Police Service rollout, and they studied 6 trials. But more importantly than that, the Information Commissioner's Office of Information Commissioner has criticised this on the basis of the quality of the data that's being used. And in particular, one thing to look for is the custody images database is not clean, which means that when people are processed and are no longer of interest to the police, they retain their images within that data set. So you can appear on a wanted list without actually being wanted. The Welsh trial, and this doesn't appear in the Evans judgment, noted that during 55 hours of deployment, 2,900 potential matches were flagged up, of which 2,755 were false positives. That's quite a large number of false positives. It highlighted in particular that one woman spotted on the who was on the South Police watch list was spotted 10 times, and none of the people spotted were her. So I had another look at reliability by running my own image through Google, and here's my Chambers profile picture, and this is what it throws up on Google. If you do an image search, it says that I'm a woman. That's quite helpful. And then I tried it on my Twitter profile picture, and this time it decided that I was a man, which is possibly less helpful. So that's the sort of problem that you can get with facial recognition. So turning to where we are at the moment in terms of Article 8, in Bridges, they accepted that private life was engaged by the use of facial biometric information because it's a unique identifier. And then they looked at whether or not there was an interference. Now, this is where I start to have some problems with the judgment, because I think when they looked at interference, they didn't go on to look at what was interfered and how wide-ranging that interference was. So it was accepted that there was an interference. So even though it took place in public rather than private, the fact that your image was taken and processed was sufficient. However, the question of what constituted the interference isn't, as far as I'm concerned, sufficiently looked at. What constitutes the interference? Is it the taking of the photograph, the existence of the system, the comparison with a watch list, the impact on the behaviour of an individual or group? So, for example, it's much more of an interference if the social impact of the surveillance existing is that people won't then go and protest, or they won't go down a particular street, or they won't walk next to their friend who they know is involved in a protest movement, or their family member. But none of that kind of breadth of interference is really considered. And the other problem for me with bridges is that it starts quite strong. So AFR is a new and powerful technology with significant civil liberties concern. Raw power of AFR and potential baleful uses carries on. It significantly enhances the system to intrude and gather private information of a citizen. And then you get a bit further on. It's not an intrusive act. It simply involves taking a photograph of someone's face and the use of algorithms to attempt to match it with photos of faces on a watch list. And so the significance of it is downplayed. And as I've said, there's no consideration of this wider consequence of the interference on groups, potential for stigmatization, or the potential discriminatory aspects of the surveillance existing in the first place. And this, to me, sums up all of the concerns that the Information Commissioner, Surveillance Camera Commissioner, and others have about the lack of a separate legal framework. We move into an area where there are continual infringements for private life without any real safeguards, because the total effect of the impact of the system, of algorithms and their use, is dissected into separate parts. So taking a photo might not be an intrusion. Compiling a watch list might not be an intrusion. What about monitoring social media to get the details for that watch list that your photograph is then compared against? Or monitoring your friend's social media and using that information to do a risk-based analysis? What if you're just walking down the street next to a person on the watch list who's identified, and this flags your image as a person of possible interest? What if your civil disobedience campaign suddenly gets you labelled as a terrorist? So all of those sorts of considerations don't really play into how serious the interference is. In terms of legitimate aim, it wasn't disputed. I query whether or not there's an argument to be had about the breadth of prevention or detection of crime. Is it all crime, some crime, very serious crime, not so serious crime? And there seems to be a confusion between what we want and what we need when you're looking at necessary. So is the system itself necessary for the purpose that the legitimate aim it seeks to achieve? The court in Bridges found that it was, but don't perform any separate analysis on necessity. And this is despite the fact that both under Article 8, the interference has to be necessary, and under the Data Protection Act, it has to be strictly necessary. So I spent some time thinking about what, why, and how we might think about necessity. And these are some of the reasons that are given for the uses of live facial recognition by the police, and some questions arising from them. And it's clear that there would need to be specific necessity analysis on each deployment of the technology. So identifying individuals wanted by the courts and police. Wanted for what? Theft, terrorism, how serious is the intelligence, how clear is the intelligence? And as I said earlier, there's a lot of dirty data in the system. Define harm. And then, is the technology sufficiently accurate and reliable to be necessary? And from what we've seen above, it's not particularly accurate, it's not particularly reliable, and it's certainly, if you balance up the number of people being surveyed compared with the number of people being detected, there's a clear imbalance in the number of people whose rights are being interfered with versus the effectiveness of it. And then, is it necessary to deploy it at all? Is it necessary to deploy in that location? And all of those questions, broadly speaking, are left hanging. In terms of proportionality, the objective pursued must be proportionate to the seriousness of the interference. And the court concluded, on neither occasion that it was used in the South Wales scenario did it lead to a disproportionate interference with anybody's Article 8 rights. Nobody was wrongly arrested. Nobody complained as to their treatment, save for the claimant on a point of principle. Any interference with the claimant's Article 8 rights would have been very limited. It would be limited to the near instantaneous algorithmic processing and discarding of the claimant's biometric data. And for all the reasons that I've set out already, in my view, the focus is wrong, because the interference happens when the surveillance camera is installed, when the AFR system is installed, and at the consequence of the system existing in the first place. So it's not the consequence of having been photographed and compared against the watch list, it's the consequence of it being there and its capabilities. And then in terms of the Equalities Act, I've started with the a line from the dissenting judgment of Kerr in Begal. The opportunity to exercise a coercive power in an arbitrary or discriminatory fashion is antithetical to its legality. Now, given the research that has now come to the fore in terms of the discriminatory effect of the technology that is in use, if Bridges is right, it needs to be reconsidered, because the technology itself is discriminatory. It's discriminatory on grounds of gender and on grounds of race. The court held that in April 2017, there was no reason that anybody should have recognised the potential for discrimination. Well, kind of beg to disagree on that, but that obviously could go either way. But in terms of the gender shades, academic research and other research, and the announcements made by IBM, Microsoft and Amazon, it's definitely up for debate now and ought to be reviewed as a matter of urgency. Discrimination has an impact on in accordance with the law and legitimate aim. You have also got potential discrimination in the compilation of a watch list, if you see the historic data on over-policing of communities in the Lamy report, and then future issues such as discrimination in the location of live facial recognition. So the University of Essex report refers to Westfield Shopping Centre, which is where one of the trials took place. And actually the crime area that it was seeking to police was over the other side of the train tracks. And so there's a clear issue as to what the actual purpose is of that deployment. So what next? Following on from live facial recognition, we have research on artificial intelligence that shows automated inference on criminality using facial images. That has been discredited to a degree, and this is again partly due to the fact that the data that it's trained on is old data which contains biases. Use of social media to impute political viewpoints to people, which again could be relevant to whether or not you got included on a watch list. And this isn't just your own view. So that there is current research that suggests that even if you're not on Twitter, for example, but you have contacts who are, I think it's about 8 or 9 contacts, your political viewpoints can be imputed from your circle of acquaintances. There's been detailed analysis of some of this by the Centre for Data Ethics in the UK, looking at predictive analytics. So where should we locate our policing? Who should we be policing? And how is that going to work? So that's the scary future. And then I come back to the picture that I started with, which is none of this matters a huge amount if after you've been to your protest, you go home and post your pictures all over publicly available social media. Thank you.
Brilliant. Louise, thank you so much. That was fascinating and scary all at once. Lou, you've disappeared, but I've got quite a few questions for you, so you've got to come back. Could you take your slides off the screen? Because
Yeah.
Thanks. Brilliant. I'm just going to get back to the chat. I'm going to put the questions for you first. I should say, Kate Gould thinks you need to rush down to the Court of Appeal right now, so perhaps we shouldn't detain you with answering these questions. But is AFR now, or will it be installed on street CCTV? Do you know the answer to that?
I know that live facial recognition is subject to a whole documented process by certainly the Met. So I don't think it's just installed everywhere. I think they have to go through a process of deciding that they need to deploy it, what they're deploying it for, and who they're targeting. So in each case that it's been used, it's been targeted with very specific watch lists designed to target a specific purpose.
Okay, and do you know whether there has to be some sort of warning notice if AFR is being used, and the analogy has been made with ANPR, you know, when police have to put those notices up to warn you that you're being filmed, or that your number plate's being registered.
They are supposed to warn you. The criticisms that have been made of the warnings are that they tend to put the warning notice in front of the camera. So to read the notice, you have to stand in front of the camera. So by the time you've read it, it's too late.
Oh. Okay. A big question that a number of people have asked, and I don't mean to just put the spotlight just on you, Lou, so if any of the others want to chip in, they'll let me know. But in terms of, is there any way, and I suspect the answer is no, that you could find out whether you're on a watch list by making an FOI or a SAR?
I mean, I think you probably could. I don't think you could find out who else is on it, but you could probably find out if you were. But then if you were wanted, you might not want to
make the request. Well, your solicitors could make the request, for example. I would have thought that it fell within an exception, but that's just me. I think, Jude, have you had experience of that?
No, I'm just thinking about it as a comparative thing to the Matrix.
Exactly.
Yeah, where you can't get anything. So this is just another version. This is a visual version of the Matrix, or partly. So I'd be very surprised if they'd let you know, to be quite honest.
Yeah, I would have thought it would have fallen into the number of very broad exemptions. Particularly if there's any kind of but if there's no prosecution intended, of course that's that bit gone. But yeah, I don't know.
The one thing that you might be able to do if you're no longer on a custody watch list, or if you should no longer be on a custody database record, is make sure that's clean.
Yeah. So I'm just going to go back to the I think Matt Foote has asked whether AFR is used anywhere else in the world, and one of you, Rona, has answered that it is currently used at the on the West Bank in checkpoints to quote unquote allow Palestinians to cross, and China as well. Lou, do you have any further experience?
It's used in a lot of body camera in the US, so there are a few states that have banned it, but most states haven't.
Okay.
I don't know.
That's all right. So there's another question here. It says, anyone reviewed how the Met targets the facial recognition? If this is based on bad data, won't it be biased on racial grounds due to over-policing? Reference to Lamy. I think that's probably a question of, you know, when they've got it wrong, who's checking, who's reviewing their data set?
Well, there is the advisory board that has been put together, and I was just having a look at their sort of terms of reference this morning, and the sorts of objectives that this advisory board have are to ensure the use, including composition of watch lists, conforms with legislation and codes of practice, use adheres to scientific quality and ethical standards, ensuring that there is proper evidence base for decisions, making recommendations to police forces on best practice, etc. So there is a new biometrics oversight advisory board that I imagine would feed into that. But the membership is comprised of a representative from the Association of Police and Crime Commissioners, a representative from the Home Office, and then Surveillance Camera Commissioner, the Information Commissioner, Biometrics Commissioner, Forensic Science Regulator, and so on and so forth. So it's not a it doesn't seem to be an open board that sort of ordinary members like us could be on.
Okay, Mike, I've got one for you. You ready? Does a kettle to prevent breach of the peace give the police grounds to apply a blanket search power?
That's actually one I know the answer to as well, so that's good. No,
Phew.
it doesn't. Kettling has no impact at all on the power to stop and search. The reason that blanket stop and searches were issued or put to the Kettles as they were leaving, the Kettlees, the detainees in Mengeisha, and more recently at the Black Lives Matters protests, is that the police, before the protests, had put in place what's called a Section 60 order. So normally, the main power that's used for stop and searching people in the street is Section 1 of the Police and Criminal Evidence Act, which allows police to stop and search if they have reasonable grounds to suspect someone's carrying a weapon or prohibited item. And then there's a similar provision in the Misuse of Drugs Act that allows them to search if they've got reasonable grounds to suspect someone's carrying drugs. But if there's various criteria that need to be fulfilled about having belief about serious violence likely to break out at some point, but they can get an order under the Section 60 of the Criminal Justice Public Order Act 1994, which applies to a specific geographical area, like a section of London, that allows them for a specific time, 24 hours, could be longer, to conduct a search on anyone without reasonable grounds to suspect. And so those orders were in place over the areas where the protests took place, both in the case of Mengeisha in 2012, and a couple of weekends ago. So that's the basis on which they were allowed to stop and search everyone. What's an interesting question, I think, which wasn't really answered, is although you can search people without reasonable grounds under Section 60, I think there's an interesting question of how long you can detain everyone in order to search everyone. Because although there is a power to stop and search, similarly the purpose of a kettle is to prevent a breach of the peace. Now, once you're releasing people, if it's going to take hours to search every single person there, or a long time, aren't you in effect extending the kettle by requiring everyone to remain to be searched? Now, it wasn't really addressed in the case of Mengeisha because it was kind of conceded that the police did have the power to stop and search, perhaps because they thought they were on stronger grounds, and they were on stronger grounds, on the issue of taking personal details. But I mean, to take an extreme example, if two police officers turned up at a football stadium of like 70,000 people and said, right, there's a Section 60 order in place, we can search all of you, you're all detained until we've searched you, at some point, the period of time it takes to do that is going to amount to deprivation of liberty, one would think. So that question hasn't really been answered. But in general, the issue is about the reason there was a search is that there was a power under Section 60 of the Criminal Justice and Public Order Act.
Okay, well, we're supposed to finish in a minute, but I've got a few more questions. Mike, I'm sure you know the answer to this, but in light of the COVID legislation, which effectively prohibits more than 6 people gathering together, what is the impact on that on protesting? Does it make public gatherings unlawful?
I mean, this is being debated at the moment, isn't it? I think the quick answer is probably yes. I think actually, I think this was specifically part of was this part of last week's seminar or possibly on the upcoming one? So my apologies that I'm uneducated as some others, but I think the quick answer is yes, but there's clearly a balance to be struck between the laws against public gatherings contained in the coronavirus regulations and individuals' rights to assembly and freedom of expression under the European Convention on Human Rights. So an argument that the coronavirus regulations necessarily ban all protests. I mean, the police came out recently, police in Scotland, I noticed, came out quite strong and saying politicians need to get their act in order and tell everyone they have to stop protesting. The regulations say you can't go mass gatherings and there is no exception for political gatherings. Well, it might be right that that's not included within the regulations, but of course, human rights create a different situation for political or protest gatherings. So it's something that you would have to challenge in the courts if you were arrested under the coronavirus regulations for attending a demonstration, and it would probably involve asking the court to strike a balance on competing these two, on the face of it, arguably competing provisions.
So I'm going to quickly just ask you a couple of Kettling corona questions. Should COVID-19 effectively stop the police from kettling, given that it might bring people closer together and thereby spread the virus?
Well, from a common sense position, yes. I mean, from a legal position, I'm not sure how that would apply. I mean, if it is illegal under the coronavirus regulations for the people to be out in a mass gathering, that's what's already caused it. The police would argue that we can't be blamed for just putting a cordon around the people that were already out gathering. I mean, could you argue that there's some kind of health and safety duty of care that they are?
Well, it's difficult because the people there themselves, unless they have worn masks.
I think it would be a real stretch. Because the basis for the legality of a kettle is that you're already in a situation where the situation is exceptional and that there's a real imminent risk of disorder, or disorder is kicking off, and so you have to use this provision. If you've satisfied that test, I think it's unlikely a court would say, okay, there was an imminent risk of serious disorder, or disorder was kicking off, this was exceptional, but people might have breathed on each other, so in that case it's unlawful. I think any case where the police would have been able to justify putting a kettle in place in the first place, the court would necessarily, I think, conclude it was serious enough that it overbore any concerns about transmission of the virus.
I'm just going to do two more questions. First, one is a point of information. Tom Wainwright in our chambers has just reminded me that the answer to whether you can protest during the pandemic it was answered last week and is available. So we can send you, if you want it, you can just ask for that webinar podcast or whatever it's called, and then you'll know. There's a couple of questions on whether there is any prohibition on kettling under 18s who are on their own. I suspect not, but if there's anything specific, Danielle or Mike, I don't, as far as I'm aware, I can't.
Something else. What was the question? Sorry,
whether there would be some kind of prohibition on kettling an under 18 who was there without their parent or guardian or over 18 person. I'm aware that there wouldn't be, and I've not known there to be. In fact, I've known there to be children who have been kettled. So
yes,
there's
there's no law. There's nothing in the guidance that says once a kettle is, as most of the guidance is in the case law. There's nothing that says that once a kettle is established, the police cannot let anyone out. I mean, the kettle that I was in that gave rise to Mengeisha, one of the legal observers was a more elderly person, had travelled from some distance, really needed to get home. We managed to convince the police, after some begging effectively, to let them out. So if you've got a youth inside a kettle, there's nothing to stop them from going to the police, and it's a factor the police should take into account about when considering whether to let them out. But equally, there's no automatic right to be released just because you're a youth. But I would imagine it's something they should take into account if they're approached by someone saying, "Hey, I'm 13, I need to get home. Can you let me out, please?"
All right. So just last question for you, Danielle. Can the police remove your face covering? I mean, they have the power to lawfully.
My view is not, and the court sort of touched on this in Bridges, around paragraph 73 and 75, where they drew comparison between the use of the LFR technology and, for example, taking fingerprints or taking swabs from people. And they said, well, the reason, power can be derived from common law for the use of LFR is because it's not intrusive, there's no application of force, whereas fingerprints and swabs there is. Hence why there's specific legislation for that to take place. So I would say that if the police are physically using force to remove a face covering, then that's outside the common law powers, following the court's observations in Bridges. But I was aware that there were allegations that was being done. And I certainly know from my experience on the ground that there were some people that they were doing that to and others that they weren't. Some people were allowed to walk past with the face covering on, which would obviously interfere with the software. But that's my view, that no, that wouldn't be permitted, and that would constitute an assault.
All right, and presumably if you had a face covering because of COVID, you couldn't possibly have that removed in any event.
Can I interject on that point?
Yes, quickly, Mike.
Quickly, there's a power under Section 60AA of the Criminal Justice and Public Order Act. In the same way that they can put in place a power that police can stop and search everyone of a geographical area without reasonable grounds, they can also put a power in place that they can require people to remove face coverings if they believe that the purpose is for concealing identity. And in fact, I think actually now it was amended, that power automatically applies if one of the stop and search orders is in place. So I understand that if they put a Section 60 order in place, the police can require people to remove facial coverings reasonably believed to be for the purpose of hiding identity. Now that makes it a bit difficult in the current circumstances because people are wearing facial coverings for health reasons. But if the police can argue, well, hold on, we think the real reason was to hide identity, and that's a reasonable belief, then I think actually they are entitled to. I think
I would agree with that, and I think there's an interaction between the COVID law then and Section 60A, which probably would end up having to be fought out in court, because the police could argue that it was unlawful for you to be there in the first place, and therefore even if you were socially distancing and taking COVID precautions by putting a face mask on, that the other laws around Section 60, etc., would take precedence. Obviously, we don't know; it hasn't been fought out in court. But I agree with Mike. There is definitely that provision under Section 60A.
Right, okay, so thank you all so much for spending your lunch with us, and can I encourage you to come back next week and the week after and the week after. In fact, as long as we run seminars at lunchtime, please come back. It's been fantastic to have so many of you here with us. I'm going to do what Ches said and save the questions by asking Amy to. Amy, are you there? And downloading them, and if we can circulate those, because some of you gave good links and answers that other people want. So subject to any data protection issues, we will include those when we send out the pack to you of the slides, PowerPoints. So thank you to our speakers. Thank you to you all for coming, and see you next week, I hope.